Good morning or good afternoon, whatever the case may be for you. My name is Kyle Felty. I'm an attorney in North Palm Beach at Cohen Norris, Wilmer Ray, Telletman & Cohen. I've been practicing there about 3.5 years, and I've been a practicing attorney for just over 5 years now. Prior to becoming an attorney and prior to law school, I was a real estate broker. So I did a lot of real estate brokerage. I went to law school, and now I'm a real estate attorney. My primary area of focus and practice is real estate law. So today what we're going to do is we're going to talk about landlord-tenant law. For young attorneys, it's a good area to get into because inevitably almost everybody you know is typically renting a place. And as you get into your practice, you'll meet people that are landlords as well who will need your assistance. We're going to go over residential leases. I'm just going to talk about the ins and outs of residential leases, things you need to look out for, how to protect your client. We're going to talk about settling disputes. We're going to talk about defaults, how to terminate a lease, that kind of thing. We're also going to go into, towards the end, we're going to go into commercial leases and how those are different from residential leases. And we're going to talk about the commercial eviction process just a little at the end. I'll try to spend most of the time on residential leases because that's probably where the bulk of the landlord-tenant work that you'll be getting will be. So as I mentioned, residential leases is a good area of practice. It's a nice area of practice for a young attorney because it's something that everyone's dealing with, and probably a majority of you deal with it yourself. You've signed a lease, you're in a lease, you're in a month-to-month tenancy, something of that nature, and the majority of your friends are as well. So it's something that's familiar to you and you know about it, but we're going to go into details today. One thing to note on residential, not so much commercial, but on residential leasing, it's very important that you don't, I try to make it a point to not over-lawyer the situation. You have to take sometimes a practical approach. So although, you're a new attorney and you're out and about and you want to find the case law and you want to, take this action, that sometimes the best way to settle it is via a very practical approach. Okay, so it's people-oriented. You have to keep that in mind. A lot of times, if you represent a landlord, the tenant's sometimes behind in rent because of a legitimate hardship. So although we'll go over the statutes today, I'll also give you some pointers on how to handle people situations. You're not just a lawyer, you're a counselor, and your client will want you to counsel them on how to handle a situation. Sometimes taking the extreme legal position isn't always the best. Sometimes it's best to, certain settlements are sometimes favorable. And in residential real estate, you'll find when you start going to court, there's some judges in county court that are very tenant favorable. Okay, so although some landlords may think the tenant hasn't paid the rent and without a doubt they need to leave, sometimes tenants can come into court with a hardship or a sob story, for lack of a better word, and the judges or sometimes show leniency with respect to that. In that same respect, the statute we're going to talk about is Florida Statute 83. And if you look at 83.44 and 83.45, these are as they relate to residential. So the Florida Statute 83 is broken down into residential and non-residential, and then it goes into storage facilities, which we won't talk about today. You'll find that the residential statute is much more comprehensive. The commercial statute relates primarily to landlord liens and things of that nature, but the residential, the Landlord-Tenant Act in Florida Statute 83 is comprehensive, and it's pretty straightforward. It's almost to an extent where an individual could help themselves and read the statute themselves without the assistance of an attorney. 83.44 and 83.45. 83.44 states that the parties must act in good faith. 83.45 allows that if there's any term in the lease that is unconscionable, the judge can strike it. So again, it goes back to being practical. If you're drafting a lease or if you have a tenant that's signing a lease, the point of that is to prevent landlords from taking advantage of tenants, and I guess vice versa. But you have a duty, everyone has a duty to act in good faith and to not put any unconscionable terms in a lease. So two types of leases primarily. You have a written lease and then you have what they call a verbal lease. As we go through this presentation, I'll make a few pointers on if you're doing a lease, things you want to add into the lease. As a young attorney, I don't know that you'll get a lot of calls for people asking you to draft a lease. The reason being is that if they have a realtor, most realtors, there's a form the Florida realtors provide that's very comprehensive, and it's a decent form. And when you're starting, it's good. In real estate, it's good to use the form in a residential deal where it's been tried and true, and the language has been tested, and it's been drafted by attorneys who are familiar with that area of law. But you do want to review it. You do want to find out if there's anything peculiar about the tenancy that you're going to be drafting the lease for. You do want to talk to the landlord, talk to the realtor if they referred it to you, get information, and you want to make sure, you still have to read the document even though it's a boilerplate document and everybody uses it, and make sure it fits your client's needs. You want to look at, there's a requirement that you disclose radon gas and lead-based paint. You want to address, can the tenant assign the lease? You want to make sure the tenant acknowledges that their lease is subordinate to any mortgage or lien the landlord might get. So those kind of things I just referenced are in the form Florida Realtors lease. So that's why I suggest you start from there. I don't suggest you start from scratch and type up a lease. Ask a mentor for a form, for lack of a better word. Use the Florida Realtors, the Florida Bar. I may have a form lease. You can call or email me. This is a point where we flash my phone number. Call now. You can call or email your mentor and get a form. Don't just start from scratch, because there's a lot of things you'll want to cover that are required to be disclosed that we're not going to go over today because we don't have the time to go over every single detail that you need in a residential lease. But start with the form and go from there. One big point is the statute of frauds, which you've all learned, is if the lease is for more than 1 year, it's any lease, okay, you're conveying a piece of real estate, a leasehold, it has to be in writing and signed by 2 witnesses. Okay, so that happens often. We have people that do these leases, and then the tenant wants out, the landlord wants out, and you say, send me the lease, and we get it, and it hasn't been witnessed, properly executed, and either party has an argument that it's voidable. Okay, so if it's over a year, make sure it's signed and witnessed by 2 people. The form Florida Realtors lease that most people use throughout the state, in Palm Beach County, and I think throughout the state, states at the top, it has a big notice that says, notice, if this lease is for more than 1 year, consult an attorney. Practically speaking, the only real difference is you got to have 2 witnesses. But you'll get calls from realtors maybe or friends, and they read that provision and they say, hey, the lease is for more than a year. Attorney friend, what do I do? So don't get too scared. It's pretty simple. Just make sure you have 2 witnesses if it's over a year. If it's less than 6 months, a lease, you got to worry about sales tax. Okay, if the Department of Revenue says if it's less than 6 months, you have to pay sales tax. Also, check with the municipality. If you represent the landlord, have them check. Some municipalities have a rental tax. Okay, so here in West Palm Beach, you have a rental tax. So you want to check on that, and you want to advise your landlord or your tenant that they may be responsible for additional taxes. Okay, that's important. Verbal leases, I guess several kinds. You have at the end of the term of a lease, it automatically kind of converts to a verbal month-to-month lease under the same terms. Or if you're paying rent monthly, it converts to a month-to-month lease. If you're paying rent weekly, it converts to a week-to-week lease, etc. And all that's in the statute. You also have just verbal leases in the situations where landlords just lease someone and say, pay me X dollars a month. And there's no lease, and that's okay. That's still, it's still doable. The bad side for the tenant is he doesn't have it locked in, and the same thing for the landlord. He doesn't have the tenant locked in for a long period of time. You're relying on the guy to pay month to month, and he could leave at any point. And I'll talk about how you can terminate written leases and how you can terminate verbal leases later on in the video. Now I'm going to go in Florida, we have a lot of condo and homeowners associations. If your landlord or your tenant's leasing a place that's in a association, not only do you have to comply with the laws of Florida, the building codes, health codes, you also have to comply with the rules of the association. So it's important in the lease to address, does the association require approval? Many condo and homeowners associations, I would say the majority of the newer ones, require that if you're a landlord leasing a premises, you have to get the approval of the association. Okay, there's an application fee and that kind of thing. So before a lease is signed, make sure they've got that, your tenant makes that application, or when you draft the lease, you make sure, especially if you represent the tenant, that there's a contingency that it's subject to the approval of the association, okay? And as a side note, if you know somebody's buying a property as a rental, because you've watched this video now, you know a little about landlord-tenant law in Florida. You want to tell, if you have someone buying a property for a rental, you want to make sure to remind them, make sure you check with the association, check the declaration, because there may be restrictions on leasing. Some associations don't allow you to rent for the first year. Some of them only allow you to rent so many times per year. So it's very important, and the association and some associations are very strict. So just like you worry about the law, the statute, the case law, you also have to worry about the association rules and regulations. Also, associations have the right, by virtue of Florida Statute 718 and 720. This is outside of Florida Statute 83, covers all our landlord-tenant, but 718 and 720 govern associations. So in 718 and 720, it gives associations the authority, if you're an owner in default, you're not paying the association, to step into the shoes of the landlord and begin collecting rent from the current tenant. So it's, in essence, what it prevents is these absentee owners that say, I'm going to foreclosure, I'm not going to pay the association, I'm just going to collect the rent as much as I can until it goes to foreclosure. Well, they put the statutory provision there to prevent that. So associations can go in, step into the shoes of the landlord, they can collect rent, and they can also evict tenants. So, important to know, because you may have someone call you that the landlord's in foreclosure or landlord's in default with the association, and the association may reach out to them and demand payment. And when they call you, now you'll know, yes, they can do that. So that's how that works. You also want to include a provision in the lease, if you're the landlord, that any violation of the association rules is a breach of a default of the lease. Why? Because if you have a tenant who's constantly throwing parties till 4 a.m. and the association's fining the owner, you want to in turn be able to evict the tenant. Okay? If they're breaking the rules of the association, you want to make sure you have the right to evict them. And the association has that right within their documents. But if you're current on the association dues, it's unlikely they'll do that. They'll probably just fine you till you fine the landlord till the landlord kicks them out. Leases, I feel like every time I get through one of these, I want to say, any questions? So if you have questions, you can email them, I guess. With respect to a sale of real estate, how does a sale affect a lease? You often are going to get calls. You're going to have clients that are going to call and say, I just got word that they're showing my property, the landlord's trying to sell my unit. What do I do? I need to stay in here. He's going to kick me out. He's told me I got to leave by X date. Well, the answer is, if you have a written lease, unless there's a provision in the lease that says the landlord can terminate with so many days' notice for whatever reason, unless the lease contains a provision that specifically allows the landlord to terminate it, the landlord can't just kick you out, okay? Doesn't matter if he sells it. Then the new owner has to honor the lease. So generally, when you have a landlord that's selling a piece of property and there's a lease that encumbers it, there's a presumption that the security deposit is transferred to the new owner, okay? So as a tenant, you'll look to the new owner because there's a presumption of law that the new owner, the new landlord, has the security deposit. Now, how does that work? As a sidebar, I guess, when you're doing a residential transaction, generally you get the landlord will reach out to the tenant and get what we call a tenant estoppel letter that says the tenant signs, I'm Joe Tenant, I pay X dollars a month, my lease ends on blank date, I have blank as security deposit, I've paid blank in advance. He signs that, the buyer can see it, the buyer confirms those terms, and then at closing, the security deposit and the advance rent is prorated and transferred to the new owner. So the new owner should have the security deposit, should have any advance rent in their hand. Make sure if you represent somebody that's buying a piece of property that has a tenant in it, that they get that tenant estoppel letter, because if you don't, you knock on the door and say, hey, Joe Tenant, I just bought this property, you can make your rent payable to this address, and Joe Tenant says, what rent? I paid a year in advance. And of course, that's a lie, and he's trying to, maneuver it favorably for him. So you make sure you get that tenant estoppel so the terms are clear and there's no confusion. So when your new owner takes over, it's clear on what the terms are. Also, if you represent a tenant, same kind of thing. it's nice to have that tenant estoppel so you and the new owner start off on a fresh, nice footing, and there's no confusion, there's no misconceptions about what the terms are, and everything is clear. So in a sale, make sure you get that tenant estoppel to make sure everything's clear with the new owner. If you use on a residential sale, if you use just like we use the Florida Realtor form of lease, a lot of times you'll get people will send you to review. They use the FAR, which is Florida Association of Realtors, and Florida Bar form of contract, which has provisions that are very good and acceptable for how to handle a tenant in a sale. Okay, so if you have somebody you're representing, a tenant or a buyer or seller of real estate that has a landlord-tenant situation going on, just refer to the contract. It's very clear and it's very helpful. Yeah, you don't have to memorize these laws on the residential side, because a lot of times they're all statutory. You look at Florida Statute 83, and most of the time you can address your issue within the wording of the statute. You don't have to look at complex case law. You don't have to call tons of people to get the answer. Generally, and why this area of practice is good for young attorneys is that most of it is statutory and most of it's pretty straightforward. Foreclosure. Foreclosures are dying down now, but over the last few years we've had a lot of foreclosures, and there was a lot of changes and adjustments to landlord-tenant law because of foreclosures. Because you have tenants paying rent and they have a long lease and the property's foreclosed. Well, what happens then? If the bank takes over, does the bank just get to kick you out? If a third-party purchaser buys it at foreclosure, do they come kick in the door? Well, we used to have a law there was a federal law called Protecting Tenants at Foreclosure Act. And it was a federal law, so of course it was lengthy. But what it basically allowed for is if the bank took over, they had to honor the lease. It was a bona fide lease, okay? If it wasn't a bona fide lease, they could go into court and say you're paying below market rent, or it was your buddy and this wasn't a bona fide arm's length lease. But generally, people had to honor the lease, okay? Well, that expired, and now we have a Florida statute that governs foreclosures. So if you're a tenant in a piece of property and it's in foreclosure, it's important to know your rights. So I guess hopefully not you, hopefully your client. So if you have a client that calls you, and this happens a lot, because they get notices at their home that the property's in foreclosure. They see there's a trial upcoming or some kind of hearing, and they panic and they think they have to move, okay? They don't have to move. Florida statutes allows for, if you're a tenant in a piece of property, no matter who buys it, you have 30 days after they give you written notice, okay? So what happens at foreclosure is the title's transferred to the new owner, whether it be the bank or a third-party purchaser. At that point, they give you a 30-day notice that says, I'm the new owner, I bought it at foreclosure, pursuant to the statute, you have 30 days to vacate, and from that date, they have 30 days to the tenant has 30 days to vacate, okay? At that point, if they don't vacate, because there's a foreclosure case open, they don't have to go through the typical eviction process, which we'll get into a little later. They can just go into the foreclosure case and file a motion for a writ of possession, and it's a little quicker because depending on how foreclosure courts move in your jurisdiction, because they don't have to file a whole new suit. Okay, so foreclosure. The key thing to remember is you still have 30 days after a certificate of title is issued, and there's nothing to say. Again, take a practical approach. If somebody buys a property at foreclosure, always think, practically, and don't always think in black and white in the law, because practically speaking, perhaps before you object to everything as the attorney for the tenant, or before you insist on evicting the guy, if you represent the third-party purchaser, the new landlord, maybe there's something that works out. Perhaps the guy wants to buy the property, okay, and your landlord may want to sell it, or perhaps he wants to pay market rent to the guy and rent it out for a certain period of time, okay. Also, as a practically speaking, you want to be nice to the guy in the properties. You don't want him to knock out the walls and windows and hit the road. Okay, so that's the law is 30 days, but think outside the box, be creative, and there's a possibility to add value for your client if you can determine that maybe the tenant wants to buy it or knows somebody that wants to buy it, and the guy wants to sell it. Think outside the box and communicate, and you could add value to your client that way rather than just giving the 30-day notice. That's it on foreclosure. So now we'll go into maintenance and access, which is a common, the landlords and tenants often butt heads on this, right? Because tenants don't want the landlord busting into their house when they're taking a nap in the afternoon on the weekend, and the landlords it's their property, they don't want to be prevented from accessing it, okay? So you'll get calls that say, hey, the landlord wants to come to my house at 9 a.m. Saturday and I'm busy, I'm having people over. And then you get calls from landlords that say, this tenant won't let me in, he's making me give him 36 hours notice. So that's covered at Florida Statute 83.51 and 83.52 and 53. Oh, I'm sorry, just 83.53. I'll go back to 851 and 52. Essentially, landlord can access the property to preserve it. He doesn't need permission if the tenant's unreasonably withholding permission, if there's an emergency, if there's a hurricane coming, if there's if they have to preserve the premises and there's a hole in the roof and there's a flood. Obviously, those are emergencies. Those are reasons that the landlord can go ahead and access if he can't get a hold of the tenant, if the tenant doesn't give him access. For any other kind of access, if the landlord just wants to inspect the premises, if the landlord wants to present the place to a potential new tenant or potential buyer, in that case you have to give reasonable notice. Generally, reasonable notice is 12 hours. But again, practically speaking, it's good to keep a good relationship with the tenant and go ahead and give them as much notice as they need and try to coordinate it and have the parties cooperate. But generally 12 hours notice on that kind of thing. On maintenance, the tenant is essentially responsible for, first of all, whatever's in the lease, okay? The lease should be specific as to who's responsible for what. But per the statute, if the lease isn't specific on it, the tenant's in a residential lease is generally just responsible for keeping the place in decent condition, okay, and reporting any damage or anything to the landlord. So if the tenant's responsibility, unless the lease says otherwise, is generally just take generally good condition of the property. Don't intentionally, break a window. Don't intentionally, stain the carpet. Just generally keep the place in good condition, okay. Landlords, however, there's a laundry list of things they have to do. You have to, obviously comply with any building and health codes. Keep the property in good structural repair. Plumbing, keep the plumbing in good repair. You have to provide heat. I guess in Florida that's not as big of an issue, especially here in South Florida. You got to provide running water and hot water. You got to get rid of pests. You got to be responsible for if there's wood-destroying organisms or rats in the attic or whatever the case may be, that's your responsibility. You also have to provide a place for trash disposal so they can get rid of their trash. So, and there's other things as well. So there's a laundry list of things that landlords have to do. When you're if you do a lease, if you get into the landlord-tenant matter before there's a dispute and you're drafting a lease, you want to make these things very clear. Make it clear who's maintaining what. Is the tenant going to, take care of the air conditioning unit? Is he going to replace the air filters, for instance? If there's something quirky about the property, the pool, for instance, is the tenant going to be responsible for pool maintenance, or is the landlord going to be responsible? That kind of thing is not in the statute. So make sure in the lease you're very specific on who maintains what, okay? Advance rent and security deposits. So in any lease, you pay, and everyone's familiar with this, you usually pay a security deposit, and that's for, to make sure you don't ruin the place. Okay, you usually pay a last month's rent. Okay, so when a landlord receives advance rent and security deposits, there's rules that govern that. Okay, you can't just, if a landlord gets advance, if I get the last month rent from my tenant and I get a security deposit, I can't go to Las Vegas and have a big party. Okay, I've got to put it in a separate account, and I've got to disclose to the tenant what account it's in, where it is, and tell them is it interest bearing or non-interest bearing, okay? And if it is interest bearing, the tenant's entitled to a certain amount of the interest that's gained on the monies. So check the statute on that. If your landlord owns more than 5 units, there's more restrictions on that. You have to actually provide a written letter, and there's language you need to put in the lease, and that's all in 83.5. I don't know. It's 83. It's somewhere at 83. I thought I had it written down. Anyway, so if they have more than 5 units, there's more stringent requirements. If you got a landlord that does a lot of this, make sure you're checking the statute to make sure what you have to do as far as security deposits and advance rent. Because if you don't do this, there's penalties involved, and the biggest downside to it is you can't go after the security deposit if the tenant ruins the property. So let's talk about if the tenant ruins the property. So when the tenant vacates the property at the end of the term, the landlord is obviously supposed to return the security deposit. If there's damage to the property, the landlord has to give written notice, and it's in the statute how you have to give the notice. And in the statute, there's actually a language you can copy and you can paste. You may have to tweak it some. But again, it's all statutory, and the language is right there in the statute. You have to give them notice that you're imposing a claim upon their security deposit for blank, 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 blank. So the statute says the landlord must provide written notice that they intend to impose a claim on the security deposit in the amount of blank dollars for the following matters. Carpets horribly stained, you knocked out the windows, whatever the case may be. So, and you can't pull back the security deposit for reasonable wear and tear. What's reasonable wear and tear? Well, there's some language in the statute about that, but generally just you take a reasonable approach. If the guy's been in there 3 years and the carpet's a little stained, that's probably not going to be reasonable wear and tear. If you end up in a lawsuit about it, some judges you'll find they tend to be, seems a little landlord favorable, some tend to be a little tenant favorable, and their definition of what's reasonable wear and tear could vary. So if it's good, it's good to settle it if you don't know, unless if you get familiar with this and you're doing this as your primary practice, you'll kind of know what in your jurisdiction how the judge is going to rule. The last month's rent, last month's rent is held in a separate account until that date comes. So if I say I'm collecting last month's rent for October 2016, I can't use that money until October 2016. It has to stay in that separate account. Some people on short-term leases do a situation where it's a 7-month lease and they collect the full 7 months. Or I've seen year leases where they collect the full year in advance. Well, the best way to do that, if you're the landlord, you want to do it, it's a year-to-year lease, it's a 1-year lease, and you pay the whole year in advance. Okay, if you're a tenant, you want to do it as it's a year lease, I'm paying the first month now, and then I'm paying the rest in advance, but it's a monthly lease. That way, the landlord has to hold it in a separate account, and he pulls it out each month. Okay, if you're a landlord, you want to get all the money in advance. If you're the tenant, you want to call that monthly rent, even though you're paying it all in advance, because if the landlord defaults, you want to be able to give him proper notice and possibly withhold rent or terminate the lease and get your money back, right? So if you're the tenant, you want to still word it, even though you're paying way in advance, as monthly payments. If you're a landlord, if the tenant allows it, some landlords just get the full amount in advance, which is great for them. And it's just a one lump sum payment for the rent, therefore they're not required to put it in a separate account. So now I'll go into kind of like defaults, terminating the lease, remedies, and eviction. We'll spend 10 minutes on that, and we'll go 10 or 15 minutes into commercial leases. So hang tight. Of course, if you're watching this on TV, you can click the bar and see how long you have to go. Watching on TV, watching on your computer. So if a tenant defaults for any reason, let's say it's you name it, they're causing a ruckus or violating the association rules. We talked about that before. If it's a curable default, the landlord has to give the tenant 7 days notice to cure. Okay? After that 7 days, if they don't cure, at that point, the landlord can start with the eviction. Okay? If it's an uncurable default, which would be a situation where the tenant's done something that's a complete violation of the lease and there's giving him time won't allow them to cure it. Okay? That you just have to give a 7-day notice to vacate. Okay? If they're late on the rent, you have to give a 3-day notice. Okay? A 3-day notice to either pay rent or vacate. When you give that 3-day notice, this is a common issue. Make sure you look at the statute. Make sure you're giving, you're only charging for the actual late rent. You're not charging for late fees or utilities unless in your lease you call those additional rent. So when you're drafting your lease, if they're responsible for utilities or late fees, call those additional rent, and then you can put them on the 3-day notice. Don't count the day of delivery. Don't count weekends. Don't count holidays on your 3 days. So you're giving them the notice on blank day. You count 3 days out, but don't count the day of delivery and don't count weekends or holidays. You can mail it, but then you have to give like 12 days. Just the best thing is hand deliver it. To really hammer it home, if you're the landlord, sometimes I have a process server. I draft it, make sure it's professional, and pay a process server to actually deliver it, sign off that that he delivered it. And then when you go into court, the tenant can't claim, well, I never received it, because if the landlord puts it on the door, the tenant could argue that he never got it. If you got a process server do it, you could bring him into court, and a process server can say, yes, I delivered that 3-day notice. It doesn't cost much money. I recommend it. So that's a pro tip. Use a process server for your 3-day notice. It costs a little extra, but it also hits home to the tenant. They realize you're serious. When somebody comes to their door and delivers something that's not the landlord or a property manager, it hits home a little more. Make sure also the 3D notice has a name, address, and phone number where they can actually make the payment. If there's a landlord default, so tenant default, you got the 7-day notice if it's curable, 7-day notice to vacate if it's not curable, 3-day notice if it's for rent, non-payment of rent. For the landlord, if the landlord defaults, they're not maintaining something, they're not doing, there's rats in the attic and they're not getting rid of them, you give them a written notice, 7-day notice to cure it. Okay, if they don't cure it in 7 days, you can terminate the lease, or you can begin withholding the rent proportionate to the damage. Now, how do you come up with that? It's kind of, you have to work that out. But if you've got rats in the attic, how do you put a price on that? Generally, you vacate the premises, and then you have the landlord abate the rent for that period until it's fixed, or you just terminate the lease. How do you terminate a verbal lease? If it's month to month, you give 15 days notice. If it's week to week, you give 7 days notice. If it's quarter to quarter, 30 days. If it's annually, year to year, it's 60 days. The most common is a 15-day. That's important to note on that. You have to give the notice 15 days prior to the end of the monthly period. So if the rent's paid on the 1st, the end of that period, let's say it's the 30th, you need to give that notice by the 14th, 15 days prior to the end of that period, okay? So if you give the notice, if it's a 30-day month and you give notice on the 16th, well, now it's 15 days from the next month. You have to give 15 days notice prior to the end of that monthly period. You can put it, can be lease provisions where the tenant has to give 60 days notice if they tend to leave at the end of the lease term, which is kind of funny. If the lease says it ends this date, it ends. But you can include a provision that says the tenant has to give notice that they are leaving at the end of the lease term, or if they intend to stay month to month after. But you can't make that notice more than 60 days per statute. If there's also a provision that's separate from that. If you can put language in the lease that says if the tenant holds over without notice, that you can charge double rent. So make sure when you get close to the end of the lease term, you make sure you're looking at it for your clients with landlord and tenant to see who needs to do what. Do we need to give them notice that we're leaving, or does it just terminate on its face? Can we stay after month to month? Maybe not. Maybe we have to pay double rent. Make sure you clarify that. Don't just assume that when the lease term is over, you're just going to keep paying rent and keep doing the same thing, because that may not be the case, okay? The terms could change drastically. Also, if there's damage making the property, uninhabitable, that you can't live in it, obviously that's cause for termination of the lease. If a landlord to actually get possession, you have to get a court order. You have to go and do an eviction. Or if the tenant surrenders the premises, in other words, I've had landlords call me and say, the tenant left and there's nothing here and the door's unlocked and he said he was leaving, but can I still go in there? Do I need to evict it? Well, if they surrender the premises, you're allowed to take possession as a landlord. If the tenant dies, if the last of the remaining tenant dies and the rent's unpaid and there's personal belongings that remain in there for in excess of 60 days and you haven't gotten any notice of any probate proceedings, then the landlord can also take possession. Also, if the place has been abandoned, and there's rules about abandoned, if the rent's current, you can't consider it abandoned. But if it's not current, you have to post a notice on the door and give them a certain amount of time to possibly respond, and then you can go take possession. If it's abandoned, though, make sure you don't just go in there, because the people could just be on vacation. Make sure if you have a landlord that's going to take possession of a premises and he says they've left or it's abandoned, make sure that you follow the statute, give the proper notice, and make sure you're not just barging into someone's house and start removing property, because then you get in you can have a much bigger issue. If the tenant vacates early, let's say they default, the landlord can take possession immediately and just end the tenant's liability. He can resublet it, he can release it and hold the tenant liable for any difference. Or he can just do nothing. He can just do nothing and try to collect the full amount of the rent that's due. Another thing you can do, it's often done, is do liquidated damages. So there's a form language in the statute that says if you're going to do liquidated damages, you can only make it 2 months worth of rent. And essentially it says if the tenant defaults or tenant wants to leave, they must pay liquidated damages amount of blank dollars, and it can't exceed 2 months rent. That's often a good solution just because it's clear, and the tenant can, if he wants out of the deal, he can pay the 2 months. Let's see. let's go big no-nos for landlords. You can't, sometimes you gotta, if you represent a landlord, you gotta rein them in. If you represent a tenant, you also need to tell them that they have rights and the landlord can't just do whatever they want, okay? Retaliatory conduct, if the tenant complains or threatens to give a 7-day notice, let's say, or goes to the building department or the health department and says, this is my property, this property I'm living in is in bad condition, the landlord can't take retaliatory conduct. You can't cut off the utilities, you can't cut off access, you can't change the locks on the door. Those are big, big, big no-nos, okay? If you do those, and the landlord's found guilty of those, the statute provides for damages in the amount of 3 months' rent. So a tenant could file a claim and get 3 months of rent as damages. And also, as a landlord in the statute, it expressly says you can't have knowledge that the tenant is going to run, a prostitution ring, sell drugs, or gamble out of the place, okay? So if you got a landlord that mentions to you that this guy, I don't know, he's going to do this and this with the property, you can't knowingly do that. Or if you know what's going on, you have to take steps to prevent it, okay? So now, eviction. It's county court. If you've never litigated, you can still do it, but you got it, although it's county court, you still do your research, make sure you're doing everything correct, but it's not that hard of a case to handle. Okay, the complaint has to contain normal things you would contain in a complaint: jurisdiction, venue. You got to have the parties. You need to have the facts clearly. You need to, expressly say the amount of the rent. That's important, and make sure it matches the 3-day notice. Okay. You can go after two causes of action. You can file. Count 1 is for possession, and count 2 is for damages. A lot of times, people just do the count 1, possession, because in most scenarios, people don't want to chase a tenant. A lot of times the tenants don't have a lot of assets to go after, and landlords just want to get them out of there and relet it. So a lot of times you'll just do the count for possession. On the possession count, they have 5 days to put the money in the court registry. If they don't, the statute says if you do a 3-day notice, you file the eviction. If they don't within 5 days put the money into the court registry, that they're to be defaulted. Now, practically speaking, that a lot of judges don't really do that. They have you come in and they make you go to mediation, try to see if the parties can resolve it, and then if the tenant still doesn't pay the money to the registry, they default them. So for an account for possession, really unless your defense is that you paid the rent, you have to put the money in the court registry. Okay, and you have an ongoing responsibility if the case goes for multiple months to keep putting the monthly rent into the registry. Practically speaking, I don't know that the judges keep an eye on it and insist that they keep putting it in there. Against county court sometimes it's not as strict as circuit or federal, so it's kind of depends on the judge and depends on your where you're located, what county you're in. Attorney fees, we'll always put a claim for attorney's fees. Make sure you're clear on your relief, obviously possession, and if you want damages, it's a separate account. Like I said, on the damages, it's they have 20 days to respond, and it's a little more complex. The possession is the easiest and quickest, and that's why a lot of landlords just go for possession and be done with it and relet the premises. Defenses to an eviction. Tenants will, and if you have a tenant that's getting evicted, defenses are improper notice. They miscalculated the 3-day notice, or they didn't have the correct amount. I've seen situations where the landlord on the 3-day notice put this large amount for the rent. They said, you owe me blank dollars, and they've included money for costs they had incurred in replacing things, and they included late fees and all this stuff. Well, they went into court. They were in court, and the judge just dismissed the case because the 3-day notice was so glaringly defective. You need to have that correct rent amount on the 3-day notice, okay, or the case can get dismissed. And then you got to refile, and you're waiting for another hearing. And if you represent the landlord, they're not going to be happy about that. If you represent the tenant, look at that 3-day notice carefully. Did they give the proper notice as far as timelines? Did they give you the date they gave you to make the payment? Was it accurate? Was it 3 days after the delivery, not including weekends, not including holidays? If not, it's a motion to dismiss, okay? Again, the tenant has to post the money in the court registry. If not, the landlord's technically entitled to immediate default, but it doesn't, if you represent a tenant, if you represent a landlord, you may want to curb their enthusiasm because the judge may not immediately enter the default. Some judges will want the parties to come in and do a mediation, etc. oftentimes the judge will show leniency. A lot of times tenants, it's county court, so it's not, don't think Supreme Court, think Judge Judy. So the tenant is going to come in there and, and sometimes they do have hardships, and sometimes you'll have a tenant and you can and you can explain the hardship to the judge, but the judges often give leniency for someone if they're having a hardship and need a little more time. They're not interested in, evicting people immediately if they're, just lost their job and, had a medical procedure or something. So keep in mind that and curb your landlord a little bit into thinking that they're going to get immediate default. Okay. Bankruptcy obviously halts it. That's a defense that stalls the eviction. A waiver. If the landlord accepts partial rent, there may be an argument that you have to reserve the 3-day notice. So when your landlord, you tell them, say, once you get involved, tell them if you get a rent payment, if it's not the full amount or not satisfactory, call me. Don't just cash it. Call me, okay? Because if you cash it, there's an argument that you waived certain claims, okay? We talked earlier about the tenant giving the landlord a 7-day notice that says, you haven't done this, this, and this. I'm going to terminate the lease in 7 days. So it's important to note, if you didn't know this, you'd think, well, if I get a 3-day notice, I'm just going to give him a 7-day notice because he wasn't maintaining the pool. The pool guy hasn't been here. Well, a 7-day notice delivered after a 3-day notice is not doesn't have the same effect. It actually has no effect. So if there's something wrong with the property, you need to get that 7-day notice out ASAP. Okay, because if you try to use it as a defense after you get the 3-day notice, some judges may allow you to use it as a defense, but generally the law is you can't do that. Okay. Other defenses, their basis for their right of occupancy. Some people claim that usually it's a family thing. There's somebody in there, and they think the landlord, they're not there by virtue of a lease. They're there by virtue of some favor for some family friend or something. That's a rare occasion. All right, so now we'll spend the next few minutes going over, we'll go over commercial leases. And on commercial leases, on commercial evictions, it's pretty complex. There's a lot more case law on it. The statute is not as clear, but you can still handle them. But you make sure everything. Make sure you find a mentor. Or you bounce things off of people. But commercial evictions are they're much more complex than a residential eviction, which is pretty routine. So today I'm not going to go into detail about commercial evictions, but I would like to spend 10 minutes going over commercial leases. This is a common thing. You may have a client that's opening a business, that's renting office space, or you may have a landlord who owns a commercial property. So we'll go over kind of the things you want to look for when you're representing either a landlord or a tenant as it relates to a commercial lease. Most commercial leases are not like residential leases. They're what they call triple net, and the triple net means insurance, taxes, and common area maintenance. Okay, so the tenant's responsible for all those things. Okay, as opposed to in residential, you just pay one rent payment and the landlord covers all the expenses. In a commercial, you're primarily doing triple net or net leases where the tenant is paying all the expenses of the property. So if you ever get a call, somebody says triple net, you know that it's tenant pays. Triple net, tenant pays. Usually commercial leases are much longer, and you have there may be 10 years, 5 years, and there's percentage increases every year. The rent will go up a little bit every year. Big thing to address in commercial leases is signage. A lot of times when you drive down the road, I do it because I do real estate. I drive down the road and I find this nice little restaurant or this little shop, and I think, man, I've never heard of this place. Why don't they have a big sign up front? Well, a lot of times it's because they didn't consult, or their attorney didn't make sure they had provisions in the lease that allowed them to put signage out front. That's a big if you have a retail tenant. That's very important that you make sure you get language in the lease concerning signage. Okay, so just put that on you should have a little checklist of things to look for. Signage is one of the big ones. Rights to renew. You can do this also in residential leases. If you have somebody that wants you to review a residential lease, if you represent a tenant, you want to give yourself the option to renew the lease. Okay, so for instance, the clause would say, at the end of the term, within 15 days, the tenant has the option to renew the lease under the same terms for a period of blank years, blank months, at the same terms herein. Okay. Your client will really appreciate it. It adds value because if they're there for a year and they decide they want to stay longer, they have an option to renew. You also option to expand or purchase. Commercial properties, a lot of times you have multiple office spaces, and the tenant wants, if the guy next door moves, I want to have the option, I want to have the right of first refusal to expand into that space. So make sure you put that in the lease. That's something that is very favorable for your tenant, and it doesn't really harm the landlord if the tenant's willing to pay market value. So, but it really helps your tenant out. A big part of commercial leases is the build out of the space. That's something, when you get involved as the attorney, you'll negotiate. What is the landlord going to do? Are they going to, are they going to really build it out and put shelves in? Is it a, ice cream shop? They're going to put a shelf in. They're going to, fix the bathroom up. And also, are they going to warrant the work they're doing? Are they putting a new HVAC in? If they are, maybe they can give you a warranty for 2 years. If something goes wrong, they're responsible for fixing it. Okay. Exclusivity, especially in retail, you want to, if your client's putting a shop in a shopping center, you want to give your client the exclusivity to be the only ice cream shop in that center. Because if the landlord rents it to another ice cream shop right next door, that's going to hurt your business. So you want to make sure the landlord gives you the exclusive right to do whatever you're doing in that space. Also address use. Make sure it's clear what you're going to do in the space. Every commercial lease has limits on what you can do in the space. It's an office space, or I'll use the ice cream. I must really want ice cream. If it's an ice cream store, you want to make sure that you have the right to sell ice cream. But talk to your client and tell them, you're going to sell yogurt because there's nothing in here about, and which sounds like painstakingly detailed, but it's true. If a yogurt place opens next door, that's going to affect his business. So he wants the right to sell yogurt too. Also, what about ancillary products? Is he going to sell T-shirts that have the ice cream store's name on them? If so, you need to say ancillary retail products or cups or T-shirts. That's important, because if the landlord, and another thing to think about is, because the landlord could say, no, I've got this guy selling T-shirts. I don't want anybody else selling T-shirts. I gave him the exclusive use. And another thing to think about, both on residential and commercial, and I should have brought this up at the beginning, you always want to negotiate it and make sure the terms are not ambiguous at all, because you're not necessarily drafting these leases to enforce against the current landlord. The landlord could sell it. He could get foreclosed on. He could pass away. And in that case, now you're dealing with someone that you have no clue what kind of business person they are. You have no clue what kind of ethics they have, and they're definitely not going to honor any verbal agreements. So make sure the lease is crystal clear and unambiguous. Okay, so on use, make sure you give your client the right to do ancillary products. Zoning, make sure if your client's putting a retail ice cream store, you want to make sure that the city allows ice cream stores there. Maybe that's zoned for office, or maybe it's zoned for industrial. Make sure you can put a retail space there, and make sure there's something in the lease that makes it the lease contingent upon or conditioned upon getting those approvals. Eminent domain, you've learned about that. The government taking of property. If the government takes the property, you want to address. You want to have a clause where the tenant can get reimbursed for any government taking and can terminate the lease if need be. You want to address parking. That's another big one. Does the tenant need exclusive parking spaces? Does the tenant need parking spaces right up front because they're a retail space and they want their customers to be able to walk right in? Do you want to limit the landlord from not giving exclusive spaces to everybody but you, where when you come to your office every day, you've got to park way off, but everybody else negotiated spaces right up front. Now's your opportunity to make sure you don't get put in that kind of situation. Landlord liens, not on residential, but on commercial leases, on a commercial tenancy, the landlord has a lien on the fixtures and the personal property. Okay? Some people, they have this sort of business that they have a machine shop, let's say. They don't want the land, that's their biggest asset. They don't want the landlord to have a lien on that. So you need to negotiate that and expressly have the landlord waive it. Even if it's not in the lease, remember that the statute, Florida law, allows for a lien on a commercial tenancy. So if you have a client that has heavy machinery or expensive machinery, make sure you're negotiating that the landlord waives his lien. Also, if you're financing equipment in the unit, you need to make sure the landlord's going to subordinate to the lender in that scenario, because it's going to be hard for your client to get a loan on equipment if the landlord's got a lien. The landlord's got to subordinate. Grace periods, you always want to build in grace periods to cure defaults. And you can do that in residential too, but in a commercial deal you want to give your client, if the landlord thinks he's defaulted, you want to build in a provision, a grace period, okay? Subleasing, you want to address subleasing. if you represent the tenant and they go to the space and they tell you about it and they say, yeah, it's great, there's 10 office spaces, so I'm thinking about I can sublease a couple of spaces to my friend who does this. Well, if they're going to sublease, you need to make sure the landlord's going to be okay with it and address that when you draft the lease. We talked about getting the landlord to give warranties for certain items or improvements they may have done. If you represent a landlord, you want to make it clear that if the tenant has any work done, no contractor can put a lien. So if a tenant contracts someone to do work inside the premises, that contractor can place a lien on the property. So there's ways to get around that. You can record a memorandum of the lease, and you need to include language in the lease that says, you can't allow any contractor to place a lien on my property. So landlord, construction liens, you want to make sure you address that, especially if you're a landlord, you want to make sure you're protected from that. Insurance, you're going to want to make sure, if the landlord's going to want to make sure you have a strong insurance provision. Also, security. For liability purposes, you want to make it clear who's responsible for securing the premises. If you're a landlord, you want to make it clear that although I may have a general security guard, I'm not responsible for securing your premises. If somebody breaks in, that's your liability. And you want to address that. I think that's about it, and I think hopefully you're not falling asleep, and I hope you enjoyed it. I hope you learned something. You can feel free to look me up and call me if you ever have any questions, or if you need help with anything regarding landlord-tenant law, and good luck.